Hey everyone, welcome back to the channel where we unravel the complexities of law in Singapore. Today we'll delve into the fascinating case of Benzline and Supercars, a legal battle over a $300,000 payment filled with twists and lessons about business and contract law. First, the background. Benzline Auto held the master dealership rights for Lorinser cars in Singapore, modified Mercedes-Benz cars. Supercars Lorinser Pte Ltd, a car retailer, entered into negotiations with Benzline to become the exclusive sub-dealer of Lorinser cars in Singapore. While negotiating, Supercars made a $300,000 payment to Benzline after Benzline sent them a draft contract. The payment was intended as a deposit for cars that were to be ordered from Daimler. However, the negotiations fell through due to disagreements, particularly about providing a standby letter of credit, which was contained in the draft contract sent over by Benzline. And Benzline eventually granted the sub-dealership rights to another company. Supercars then demanded the $300,000 back, but Benzline refused. So what were the key issues? The dispute boiled down to one main question. What was the $300,000 payment for? Supercars argued that it was a pre-contractual deposit, refundable if the sub-dealership agreement failed. Benzline, on the other hand, claimed it was a non-refundable deposit for the cars. Benzline also brought a counterclaim for breach of contract, seeking compensation for lost sales in Singapore and Thailand, and damages incurred in the storage of and other costs relating to the cars which Supercars had not taken delivery of. The case also raised the broader legal issue of unjust enrichment, whether Benzline was unjustly enriched by retaining the $300,000. Let's look at the arguments. Supercars argued that the payment was made on the understanding that a sub-dealership agreement would be finalized. Supercars also argued that the basis for the payment failed because no agreement materialized. Benzline argued that the payment was a deposit on a standalone purchase of cars already ordered and therefore non-refundable. Supercars had reviewed the draft agreement before making the payment, which included a standby letter of credit clause. Ultimately, the Singapore Court of Appeal ruled in favor of Benzline, holding that the $300,000 payment was made to avoid delays in car production, not to demonstrate Supercars' good faith, and that the payment was not conditional on the sub-dealership agreement being finalized. The Court of Appeal stated that although the parties had expected and assumed that the exclusive sub-dealership agreement would materialize, that expectation or assumption had never been communicated as forming the basis of the payment. It also could not be objectively implied. The basis to be implied had to be fundamental to the transaction, or otherwise obvious to an objective observer. The Court of Appeal stated that it was inherently unlikely that Benzline would be willing to place in Supercars' hands the ability to claw back the payment simply by refusing to sign the exclusive sub-dealership agreement later. That interpretation would come close to allowing Supercars to be rewarded for its own wrong and would create a perverse incentive to withdraw that would cut against both parties' intention for the venture to proceed. The Court of Appeal noted that Supercars had seen the draft agreement, which included the contentious standby letter of credit clause, and proceeded with the payment of the $300,000 anyway. Objectively, this had to indicate that the terms in that draft agreement were, in essence, acceptable to Supercars. It would make little sense for Supercars to be able to subsequently back out and retrieve the payment due to a disagreement with a term already in the draft agreement. Since the Court of Appeal found no failure of consideration, Supercars was therefore not entitled to restitution. The Court of Appeal also stated that a claim in unjust enrichment required enrichment of the defendant at the expense of the plaintiff in circumstances which made the enrichment unjust. The Court of Appeal stated that the inquiry into whether the unjust factor of failure of consideration was present had two parts. First, what was the basis of the transfer? And second, did that basis fail? So, what can we learn from this case? First, Always clearly document the purpose of payments in business negotiations. Vagueness can lead to costly disputes. Second, when entering into negotiations, be very careful about making payments unless terms are finalized. Finally, this case illustrates the importance of understanding the legal doctrines of unjust enrichment and failure of consideration. In Singapore, a failure of consideration must be total to warrant restitution. That's all for today. Thank you for watching. Don't forget to like, share, and subscribe, and I'll see you in the next video.